Hello everyone, welcome to our new series of Law in Shorts by Clarify Law today about the topic that is evidence.
Evidence is the foundation upon which the administration of justice rests. It is the raw material from which facts are constructed, and it plays a crucial role in the pursuit of truth. In the context of law, evidence referred to any information, whether oral or documentary, that is presented in a court of law to prove or disprove of fact or issue. Definition: according to the Bharatiya Sakshya Adhiniyam 2023, 2 subclause 1e, evidence. Evidence means and include 1. All statement including the statement which given electronically which the court permits or required to be made before it by witness in relation to matters of fact under inquiry, and such statement are called oral evidence. 2. All documents including electronic or digital record produced for the inspection of court, and such documents are called documentary evidence. According to Indian Evidence Act 1872, evidence means and include all statement which the court permits or required to be made before it by witnesses in relation to matter of fact under inquiry. Such statements are called oral evidence. Second, all document including electronic records produced for the inspection of courts. Such documents are called documentary evidence. According to jurist, Bentham has defined evidence as any matter of fact, the effect, tendency, or design of which, where presented to the mind, is to produce in the mind a persuasion concerning the existence of some other matter of fact, a persuasion either affirmative or disaffirmative of its existence. Second, Phipson say evidence means the testimony, whether oral, documentary, or real, which may be legally received in order to prove or disprove some fact in dispute. Evidence under BSA 2023: first, oral evidence; second, documentary evidence; third, electronic evidence; fourth, digital record; fifth, only relevant fact; sixth, real evidence. Kinds of evidence. There are several methods of categorize evidence, and it can be classified into different types based on various criteria, particularly its nature. Different authors have proposed the different classification for evidence. Here are some common classification. First, direct evidence. Direct evidence which direct proves or disproves the fact. Such evidence is real, tangible, or clear evidence of fact which does not require any other consideration to prove its existence. Illustration: A murder B. An eyewitness to indirect is a direct evidence. The only question is whether the witness is telling the truth. Second, circumstantial evidence. Circumstantial evidence or direct evidence refer to evidence which proves the fact in issue by providing other fact. Indirect facts associated with the fact in issue and have cause and effect relation are considered to arrive at a conclusion. Third, oral evidence. Section 54 requires that all fact except the content of document or electronic record may be proved by oral evidence. Section 55 mandates that oral evidence must be direct. Oral evidence is the evidence which person giving has himself seen or heard. Such evidence is a direct in its nature. Fourth, documentary evidence. Section 55 states that All facts except the content of document may be proved by oral evidence. Section 56 states that content of document may be proved either by primary or by secondary evidence. Document is defined in section 21D of this act. The Bharatiya Saksha Adhiniyam 2023 explicitly recognize electronic and digital records as a document along with any matter expressed or described upon a substance. Fifth, primary evidence. Primary evidence means the document itself produced for the inspection of the court. Section 57. Primary evidence is the most superior kind of evidence. Illustration. Agreement in original producer before the court. Sixth, secondary evidence. Secondary evidence are admissible in case where the primary evidence cannot be produced in the court. Section 58 of this act deals with the secondary evidence. Thus, evidence are inferior to the primary evidence, and in case of conflict, the primary evidence are privileges. Seventh, real evidence. Real evidence or physical evidence is a material, tangible evidence such as an object, a tape recording, a computer printout, or a photograph. The court can examine evidence by itself. Generally, the court will hear evidence from a witness for getting on a explanation of the significance or the relevancy of the real evidence. Illustration: blood samples, a knife, a gun, or other physical objects. 8. Hearsay evidence. Hearsay evidence is the evidence by a person who has not seen himself the event or is not involved in the happening of that event but got the knowledge from someone else. The kind of evidence does not derive its value solely from the witness himself. It depends upon the veracity and competency of some other person. Illustration: A murder B. This is seen by C. Later, C told D to A murder B. D's statement is hearsay as he has not seen the event and he heard about the murder from C. C's statement is direct evidence as he seen the event of murder. Exclusion of hearsay evidence. This kind of evidence is the weakest kind of evidence. Section 60 excludes the hearsay evidence by starting the oral evidence. In all cases must be direct. Hearsay evidence is excluded in the interest of justice for the following reason. First, the person gives such evidence does not feel any responsibility, unlike a witness in the court, who will be liable to the penalties for the making false statement. Second, the person making the statement is not making it on oath. Third, the acquiring a trustworthiness of the evidence cannot be tested by cross examination. Fourth, truth is diluted and diminished with each repetition. And fifth, if permitted, gives ample scope for playing fraud by saying someone told me that. Hence, statement of witness based on information received from other is inadmissible. Ninth, judicial evidence. Judicial evidence is the mean by which facts are proved. Thus are the evidence received by court in proof or disproved of fact before it. Judicial evidence does not include fact not proved. The statement provided by witness in the court are almost termed as a judicial evidence. This is evidence produced directly in front of magistrate. 10th, non-judicial evidence. Non-judicial evidence referred to statement made outside the presence of a magistrate. This evidence is admissible only if it could be proved in the court later as judicial evidence. Illustration: dying declaration made to a doctor. Difference between evidence in civil and criminal proceeding. The rules of evidence are in general the same in civil and criminal proceeding. It binds all the state and citizen, prosecutor and accused, plaintiff and defendant, counsel and client. Exception: first, restricted application. A few sections of this Act are applicable only to civil cases, and few sections are applicable only for the criminal cases. A few examples are: first, doctrine of estoppel applies to civil proceeding only. Second, the provisions related to confession, section 22 to 24 of this Act, character of a person appearing before court, section 47, 48, 49 of this Act applicable only to criminal proceedings. Second, beyond all reasonable doubt, the standard of proof required in criminal case is higher than that of civil case. In a civil cases, the judge must be fined for the party in whose favor there is a preponderance of proof, through the evidence is not entirely free from doubt. In a criminal case, no weight of preponderant evidence is sufficient. The fact should be proved beyond all reasonable doubt. Third, onus of proof. The onus of proof is a criminal case never shift to the accused, and they are under no obligation to prove their innocence or adduce evidence in their defense or make any statement. Fourth, duty to bring fact. In a civil case, it is a duty of the parties to place their case before the court as they think. In a criminal case, it is a duty of the court to bring all relevant evidence on the record and to see that justice is done.
Thank you everyone for watching. Please like, comment, share and subscribe to Clarify Law and watch other video of this channel.